After a violent crash, Elijah Sargent was charged with second-degree assault and DUI. Prosecutors claimed he deliberately caused the crash to harm his passenger, while Sargent insisted he wasn't driving and wasn't impaired. Several eyewitnesses contradicted him, identifying Sargent as the driver and noting the female passenger's red hair shining in the sun before impact. Deputy Spencer, a highly trained collision expert and drug recognition officer, arrived among the first responders. He found the vehicle overturned and Sargent crawling out through the wreck. Though dazed, Sargent's vital signs were strangely normal, which the deputy found unusual for someone sober after a major crash. When Spencer tested his eyes, Sargent's pupils were extremely constricted and unresponsive to light. A search revealed a metal tin containing fentanyl pills in his pocket, signs consistent with narcotic impairment. A jury convicted Sargent on both charges. Now he is appealing, raising 4 claims of error. 1. The trial court wrongly denied his motion for a mistrial after a deputy testified that Sargent was impaired. 2. The prosecutor engaged in misconduct by eliciting testimony that Sargent had not denied being the driver during an earlier hearing. 3. His defense attorney was ineffective for failing to object to both of these statements. And 4. The case should be sent back to the trial court to remove the victim penalty assessment and to reconsider the decision to impose interest on his restitution. Let's take a look at the arguments.
May it please the court, Dana Nelson, on behalf of Elijah Sargent. I'd like to reserve 5 minutes for rebuttal, please.
Very good.
There are 2 main issues in this case, the motion for mistrial and then the prosecutorial misconduct claim. I'd like to focus my argument today on the motion for mistrial and then touch on the right to silence prosecutorial misconduct issue if there's time. The court erred in denying the motion for mistrial because Deputy Spencer's testimony was improper under this court's opinion and the Supreme Court's opinion in State v. Qualley. The prosecutor elicited this testimony. He specifically asked Spencer, after evaluating Mr. Sargent's pupils as a DRE, did you form any opinions? Spencer responded, yes. It was my opinion he was impaired by a drug category consistent with a narcotic analgesic. This is directly analogous to what happened in Qualley, where Trooper Stone testified based on the HGN test alone that Mr. Qualley was impaired.
I see the words used in this case after you did this as being temporal as opposed to foundational, in the sense that in Qualley, the officer testified based solely on the HGN. I reached my conclusion. Whereas in this case, the officer said, I saw this, and I saw that, and I saw this. And then I looked at his pupils, and then after I looked at his pupils, I reached a conclusion. It's not saying based on my observation of the pupils or based solely on my observation of the pupils, I reached this conclusion. So tell me why it's not temporal as opposed to foundational.
Your Honor, the officer here didn't really give any other indications of finding an impairment. He said Mr. Sargent crawled out of the car after this accident. It was upside down on his own. He did make it to the medics 500 feet away, had to go through some sort of fence to get there. The officer didn't testify that he was stumbling or anything like that. The officer specifically said he wasn't able to do much observation in this case because of the circumstances. He said because Mr. Qualley was, Mr. Spencer or Sargent, so many names in my head, was on a gurney and getting medical treatment at that time, he wasn't able to do much except for administer this eye test, which he then explained. And then the prosecutor said, so based on that eye test, did you come?
No, after.
Okay, Your Honor, the prosecutor said after performing that eye test, did you form any opinion? And he said, yes, I formed the opinion that, he said after evaluating Mr. Sargent's pupils as a DRE. So that's specifically referencing the DRE test of looking at the eyes. Did you form an opinion as a DRE after evaluating his pupils? To me, that is common sense reading of that testimony is that it was based on this scientific eye test.
At what point was the officer aware of Mr. Sargent's blood pressure? Because I understand that was something else that the arresting officer found was somewhat
Odd.
Odd, yes. Where in time did that take place with respect to the eye test?
I don't know if Deputy Spencer gave it a specific temporal time period. He did say while he was being treated, he saw this. He did not say that made him think that Mr. Sargent was impaired. And significantly, this is just an aside, but 79 is kind of elevated for a person as young as Mr. Sargent.
Well, not after a serious accident, one would think. But anyways, I'm not a doctor. I'm not.
Right, and I am not a doctor, Your Honor, either, but I just know my own resting heart rate is way below that.
Probably
so.
not now, though.
Right, no, not now, Your Honor.
There is another line of thought, though, here. Let's assume, just for sake of argument, that the officer testified improperly here, just for sake of argument here. This was a bit of a halftime motion for mistrial. The state's case wasn't even done at that point, correct?
The state had rested, Your Honor.
Oh, the state had arrested. Okay, very good then. Then there was plenty of evidence that the court had at that time with respect to the drugs in Mr. Sargent's system, to Mr. Sargent's driving. I believe it was testified by one witness. It was twice the speed limit, erratic, going in and out of lanes, very dangerous. I didn't say dangerous, but one as a juror would know that. So even if the officer's testimony wasn't considered by the jury, wasn't there sufficient evidence for the state to proceed?
Definitely there was sufficient evidence. The question is whether this testimony affected the outcome of the trial. And here, people can commit assault without being intoxicated.
Sure.
So sure, there's evidence of assault, but there was very little evidence of impairment.
Well, one would think, though, if you're driving twice the speed limit, that's not something that a person unimpaired typically would do, weaving in and out of traffic. I think there's strong circumstantial evidence, at least.
Your Honor, there was enough.
Present to a jury, yeah.
Sure, there was enough to go to the jury, and our argument is not that the evidence was insufficient. Looking at the court's ruling, the court never examined whether Spencer's testimony was improper. The court said, in ruling on the Qualley motion, and I'm not talking about the Green motion, the court said, I find Qualley distinguishable, and here's why.
But we can affirm on any basis, not necessarily the basis of the trial court ruled upon.
Sure.
And some of us here will want to affirm on that basis, but I'm just saying an alternate path here is that it may have been harmless error in light of all the evidence.
Yeah, Your Honor, I think that our argument in the brief is that it prejudiced Mr. Sargent because Valencia, the toxicologist, testified, she was an expert too, that she could not say whether the particular level in Mr. Sargent's blood would cause impairment. She said no one can really tell. There's no quantification studies out there for what causes impairment.
That's true, but then you have the driving, the erratic driving. I think that would suggest impairment. But also the blood test did identify at least 4 drugs in Mr. Sargent's system. Not sure if it was 4 or 5, but it was a number of drugs, correct?
Your Honor, I'm not sure if those were metabolites of the fentanyl. Yes.
True.
Perhaps it was broken down, but yeah, they did detect several drugs. The expert toxicologist couldn't say whether that would make Mr. Sargent impaired. Again, he had been in a very traumatic car accident. I understand Your Honor is saying the erratic driving is evidence of intoxication. Sure, it can go to the jury, but an officer's testimony, and I beg to differ. I believe if anybody reads voir dires frequently these days, jurors put stock in officers' testimony. They generally think that officers are more credible than other people. So
Law-abiding people typically do, but there's a lot of people who might not put a lot of stock in what officers say. It goes back and forth, it does.
sure, Your Honor, but I'm just saying here this officer testified based on his scientific test that Mr. Sargent was impaired. And we believe that under Qualley and under this court's opinion in Qualley and the Supreme Court's opinion, there is a reasonable probability that it affected the jury's consideration of the DUI evidence, whether he was impaired.
Was Qualley based in part upon the HGN? I mean, wasn't that part of the issue that HGN has limited scientific reliability? And we haven't really reached that result here with the pupils.
This
correct?
is a DRE eye test. It's the same. So the HGN is back and forth, and this is shining the light. But in both, the officer is looking at the individual's reactions to this external stimuli. It's a DRE eye test, and Beatty addressed DRE tests in general and said, you know, the officer can opine that this is consistent with or not consistent with having consumed a certain class of drugs, but they can't put a quantification on that. It's just not possible.
Which case was that?
Beatty, which Qualley relies on, it talks about DRE evidence in general, and also the case cited by the state, which is the Johnson case, unpublished Division 2. The court treated the HGN and pupil dilation test under the same rubric. So that makes sense, and we would ask the court to do the same here.
Thank you.
To follow up, sorry, just one more
Oh,
question.
no
on this
problem, Your
topic.
Honor.
Is it your position that a DRE can never use the term impaired? Or-
Yes, under the Qualley opinion, the DRE is not supposed to use that. I understand the expert in Johnson did use that word, and Division 2 said that was fine. Again, it's unpublished, and this court owes no deference to that opinion, and I find it unpersuasive under Qualley for that reason.
Thank you.
Thank you, Your Honors.
Mr. Pierce.
Thank you, Your Honors. May it please the court and counsel. Brett Pierce on behalf of the state of Washington. Mr. Sargent does not establish that he's entitled to relief, Your Honors. So the state respectfully requests that you affirm the opinion. DRE Spencer's opinion was formed from all of his observations of Sargent, not just a pupil test. It was pupil dilation, but it was also DRE Spencer walked Mr. Sargent to the gurney himself. He ushered him, I think was his words in the trial testimony. He observed his gait, he observed his heart rate, and DRE Spencer wasn't the one who was administering the heart rate or blood pressure tests. He was watching, neutral medics who were not investigating any sort of crime apply these medical.
The question could have been asked a little bit better. It could have been phrased, based upon the eye test, based upon what you saw, the heart rate, the gait, all that stuff, because arguably it was a narrower question.
It was an ambiguous question, and it was a unfortunate phrased answer, Your Honor, and there's no disputing that. I don't know how a DRE really can opine that somebody's impaired or not at all if they can't use the term impaired, but
Can't they say it seemed like he was affected by or exhibiting signs of having consumed?
I would say affected by would even be even more dangerous because that's the exact language from the DUI statute. But I agree with your second point.
Signs that he had drugs or had drugs in his system or something of that nature.
It's tough to reconcile quality.
Impaired, don't want to say affected by, but you want to say that yes, it's consistent with drugs in the system.
Well,
Agreed.
So let me ask you this though: can an officer testify that somebody's intoxicated? I realize that this is a drug case, but a lay witness can get up and say, "Yeah, he was drunk."
That I think is exactly the point of Beatty and Qualley, and it's a little strange. The Supreme Court has no problem with a lay witness saying that person's drunk, I can tell,
Yeah.
but they don't want an expert to say, based on all my training, that somebody's drunk, that person's drunk.
Yeah.
It's strange, but I would like to read the exact holding of Qualley to this court because the opinion is difficult to understand at times. So this comes from paragraph 27, which is on page 202, 1 second at 202. We hold that Trooper Stone's testimony that he had, quote, no doubt the defendant was impaired was an improper opinion on the defendant's guilt and therefore inadmissible. Trooper Stone based his opinion solely on a HGN test, which can indicate physical signs consistent with alcohol consumption. The test, however, cannot establish impairment by itself, and testimony to the contrary violates the limitations imposed by our decision in Beatty. So there's two limitations in that holding, Your Honor. First, I guess I'll go to the basis for the opinion first, because that seems to be what we're talking about today. It wasn't based solely on HGN testing, and it wasn't just based solely on one eye test, as trial counsel stated below. It was based on a multitude of different factors that were consistent with the trooper's training and experience. And
But the
second,
question wasn't that narrow, though. Arguably, it focused on one test, just pointing that out.
true, Your Honor. Well, the exact phrasing If we're going into specifics,
Yes, please.
because the prosecutor asked 2 questions.
Yeah, I think it was,
He-
what was the opinion that you made at the scene? My opinion was he was impaired by a drug category consistent with a narcotic analgesic.
Yes, that was the second question. The first question immediately preceding that, I think, is what counsel's emphasizing today. After evaluating Mr. Sargent's pupils as a DRE, did you form any opinions?
Right,
Yeah.
exactly. So it's a narrow question.
Yes. The problem is, as I think both parties agree, the timeline wasn't elicited in extreme detail. So it is clear from page 195 of the reported proceedings that the pupil dilation testing, so to speak, more of an observation, occurred after Mr. Sargent was already on the gurney. So Deputy Spencer's observations about how unsteady he was and his gait had already occurred. I'm not sure, however, when the heart rate and blood pressure
Isn't
testing
a
occurred.
simpler argument just harmless error?
Well, there's a couple, I'll say simple arguments, Your Honor. This is an interesting issue because Your Honor's asked about it. The simplest issue to me is that in Quale, the officer was asked, did you form any opinions on the defendant's ability to drive a vehicle, was the question. And the officer said, absolutely, there was no doubt that he was impaired. And those qualifications to his opinion were in my opinion, the true error and why Quale was decided the way it was decided. The officer gave an absolute opinion that gave an aura of scientific credibility to the opinion that is not present here. But
that doesn't mean necessarily that this is okay because of the Supreme Court. It might be okay, but isn't harmless error a simpler argument?
Harmless error, and I think that's really going to element 2 of the mistrial, Your Honor, of the mistrial analysis, because if you look at the procedural posture here, Mr. Sargent requested a mistrial, and element 1, was there an error? The court said no, and that's not an abuse of discretion because, as we know, that also happened in the Johnson case. And not only did the trial court in that case agree with the trial court positions here, the Court of Appeals affirmed it. So we can't say that no reasonable judge would not have made the decision that this court made because we have proof that other judges do make this decision. But element 2 of the mistrial test is whether the error in the trial court who's best suited to make this determination, in the trial court's estimation, did the error cause such an irregularity requiring a mistrial? And I think that is sort of equivalent to the harmless error that you're trying to articulate, Your Honor.
I mean, another way to phrase that standard is that no jury instruction would solve the problem.
I think that's element 3, Your Honor. I want to pull out the elements exactly because this is an important issue. So whether the trial court abused its discretion in denying a motion for mistrial is 1, the seriousness of the irregularity, which we've been talking about today. 2, whether the statement was cumulative of other properly admitted evidence. That really is like the harmless error analysis. And then 3, whether an instruction could cure the irregularity. I agree with Your Honor that number 2 seems to be the harmless error equivalent here, and I think that that's where you might find a reason to affirm. The trial court in this...
We just want to avoid making the Supreme Court work too hard. Give it a simple basis.
I agree with that, Your Honor. I would thank you for that. But the trial court in this case articulated that other evidence in the record existed independently to corroborate, I suppose, the expert's opinion, which was the blood testing showing that he was on drugs.
And the erratic driving would show that the impairment, because obviously there was a level of drugs in the system, but you also have to establish impairment for DUI, and the erratic driving, at least it's maybe not direct evidence, but pretty strong indirect evidence of impairment.
Pretty strong indirect evidence. And also I would submit the crash itself was evidence of impairment because no rational person is going to deliberately crash their vehicle into a transformer to punish their passenger because they're mad about a conversation. I mean, only somebody whose inhibitions have been reduced would do something like that. So I mean, the assault itself is frankly indication of impairment. But to go to your point, Judge Staub, about whether a jury instruction could have cured the irregularity, I agree. Defense counsel engaged in kind of an all or nothing strategy. Mr. Sargent's counsel didn't ask for a curative instruction at all. They asked for a mistrial. And then the court said no, there was no, well, how about you instruct the jury not to give much weight to that opinion or propose anything. So the state's position is you can affirm this on any basis in the record, and assuming that the court had been asked to give a curative instruction, the state agrees that it would have been successful.
So let me ask you this though, before we get into that analysis, don't we have to figure out or frame the irregularity? Because Quayle has two parts to it.
Mhm.
There's was the opinion based solely on this eye test? The second part is, was it an opinion on guilt?
Mhm.
And they're separate. And you raised the point in your briefing that defense counsel's motion for a mistrial was only on the first part, not on the second. They didn't argue opinion of guilt, correct?
Correct.
Okay, so then that changes our analysis on the motion for mistrial, correct?
Correct.
Okay,
Although the trial court can't abuse its discretion based on information not known. So if it wasn't told that the form of the opinion was at issue, I'm not sure the court had any obligation to sua sponte reach it. It's a very strange procedural posture. I agree. If the court chooses to exercise discretion to reach the form of the opinion as part of the mistrial versus the later ineffective assistance, and place itself in the trial court shoes and try to determine what would the trial court do had it been asked to issue an instruction that wasn't asked for about an issue that was not raised. I still think the jury instructions, which the jury is presumed to follow, could adequately remedy this. They're actually already instructed that they don't have to accept any expert's opinion. That's part of the pattern instructions, and that was given in this case, Your Honor. Trying to get the exact number for you here. I didn't write it down which number exactly, but the cites to CP 33. Witness who has special training, etc., can give an opinion. You are not, however, required to accept his or her opinion. So,
was Mr. Sargent's impairment the big issue in this case?
for the DUI, yes, but frankly, the serious charge here is the second-degree assault.
But wasn't the big issue whether he was the driver?
If you ignore all of the third-party witness testimony that he was found in the driver's seat after the car was crashed, then the issue was whether he was the driver. But the only evidence to the contrary was when Mr. Sargent testified on his own behalf and for the first time said, "I wasn't driving," even though he had waived his right to silence at multiple prior times and not claimed that before. And that, I don't know if you're asking for me to speak about the second issue or not, but I could.
No, I'm still actually on the first issue and just trying to understand. I mean, I know that some of our analysis in this has to do with the circumstances of each case and whether, in Quayle, this was the issue, whether he was impaired. There was no question he was the driver. And, in other cases where this has come up, the impairment was the sole issue or the big issue, the primary issue. And here I noticed that counsel started off closing by arguing he wasn't the driver.
Right.
That they couldn't prove he was the driver.
Right. I think counsel's strategy there is because the assault charge carried a much heftier sentence. It was a second-degree assault felony and a misdemeanor DUI. Strategy-wise, I think that counsel was trying to get the best outcome for Mr. Sargent by mostly attacking the second-degree assault, which has much higher penalties. And I'm not sure what Mr. Sargent's offender score sentencing range was, but I suspect it was more than misdemeanor DUI, which less than a year. So I'm not sure I answered your question, though.
Nope.
A couple other points I wanted to raise, Your Honor, before I run out of time here. Mr. Sargent does mention that police officer testimony is, or I should say jurors are potentially swayed by police officer testimony. I gave Your Honor some thoughts that perhaps that's not true anymore. So the legal underpinnings of that rule might change, but you're bound by the Supreme Court's decision. So that's mostly in anticipation of a future petition for review.
In this case, though, I would note that there was two essential officers or experts who testified, one of them being the toxicologist, correct?
Correct.
And the toxicologist testified that based on the drugs found in his system, she would not give an opinion on the level of, or how that affected him, the level of impairment. And in closing argument, defense counsel used that to discredit the officer's testimony of impairment. Isn't that correct?
I believe that is correct, Your Honor.
So it's not just the officer's testimony of impairment. There's actually two that they're playing off of each other.
Right, which gives the jury a reason to doubt the,
Or maybe give the reason to focus on the driving rather than on, you know, the fact that there was some drugs present in the blood.
right. Although frankly, that goes to the jury inquiry. I just wanted to clarify that little bit of procedure too. During deliberations, the jury did send an inquiry to the judge, basically asking, you know, are drugs per se evidence of impairment? And the court responded via instruction. If you look at the clerk's papers though, and the reported proceedings, Your Honor, and I know the clerk papers site is 98 to 102, but I'm not sure of the RP, but that instruction was inadvertently not given in the original jury instruction packet. It's supposed to be a part of every DUI case. And then when the jury made that inquiry, the judge gave them the missing instruction, which says, you know, there's no per se drug use. You have to believe that the person was affected by. So I believe with that context, when the jury was asked, well, if he just has drugs, is he automatically guilty of DUI? And the court said, well, here's the instruction saying no. I think we can be sure that the jury wasn't improperly swayed by the opinion testimony on impairment. They actually were reminded that they had to find evidence that driving was affected by the use of drugs.
How did the state argue impairment to the jury in closing? Do you recall?
I do not recall, Your Honor.
That'd be a good thing to look at too.
Agreed, Your Honor. Agreed.
You go ahead and sum it up if you'd like, unless there's more questions.
No, but Judge Hill?
Oh, the question I was going to ask was actually the exact question that he asked.
Oh, excellent. In summation then, Your Honors, the state respectfully requests that you reaffirm on all three issues. Thank you.
Thank you.
Your Honors, I'm going to try and follow my crazy notes here. Significantly in Quali, there was erratic driving as well. If Your Honors read that or are familiar with it, he at one point went into the, I'm not sure if it was a ditch, but way off, and then he peeled back on and he took off. And when he got out of the car, the Trooper Stone also testified that he had a strong odor of intoxicants on his breath. So in that case, arguably there were temporal circumstances there as well. But the fact that he had phrased it in the form of, based on this HGN test, I find he was impaired. The Supreme Court found that was impermissible. So it's impermissible here too. And I understand that there is a harmless error analysis that this court will engage in. But again, I think perhaps the jury inquiry goes to how important it was for that trooper's opinion that he was impaired, because it did ask whether just drugs alone are sufficient. And the trooper was really the only person that testified Mr. Sargent was impaired.
How did the state argue impairment in closing, if you know?
Your Honor, I can't recall either. I apologize for that. I don't think it's in my brief either, so.
Okay.
And going to Your Honor's question about inconsistent defenses, that's permissible. It's okay to argue I wasn't the driver and I wasn't impaired. And also perhaps that's not even inconsistent. So turning just briefly to the 3.5 issue, the prosecutorial misconduct issue, which does go to whether Sargent was driving here. And of course, as Your Honors know, he testified he wasn't. And so at the 3.5 hearing, the only statement that was at issue determined the voluntariness of that statement was what he said to Spencer at the hospital, which was the nature of their relationship. It didn't have anything to do with liability or who was driving.
Doesn't that go to the weight of the officer who testified in rebuttal's testimony? In other words, it was pointed out, I think even on cross, the officer admitted that the prior hearing was narrow.
That's true. That's true. Defense counsel did try to minimize the damage there, but the implication was like, well, he's just now saying this for the first time. But at the 3.5, he was told he could testify about the circumstances of his statements and not waive his right to silence on guilt or innocence. And that's what he did. He didn't talk about liability.
He testified at trial. When you testify at trial, it's a broader waiver than just, well, you may have testified.
Right, but his silence can be invoked at any time, and his decision at the 3-5 to just testify about the circumstances of the statement is protected, and the state shouldn't be able to draw an adverse inference from him testifying just about the circumstances of his statement. There was no reason for him to bring up whether he was driving or not. And yet the state suggested, well, he's just making this up for the first time, so don't believe him. That's an adverse inference being drawn from his exercise of his right to silence. So that goes.
At the 3-5 hearing, though, didn't he testify that he essentially had no memory from the time they left?
He said he did not remember the Miranda. Yes, he did. He did, Your Honor. But he was testifying specifically, he did not remember Miranda warnings. And then they showed him the officer's body cam and he said, oh, yeah, I guess I was advised. And so the court found that those statements, which were just concerning his relationship with Ms. Simonson, were voluntary and admissible. So he never testified about liability. In conclusion, Your Honor, the Supreme Court has treated layperson testimony about intoxication different than expert testimony about intoxication. That's because this DRE testimony has this aura of scientific reliability to it that it's going to be impressed upon the jurors. They're going to put a lot of stock into it. So we would ask the court to reverse Mr. Sargent's convictions. Thank you very much.
Following these arguments, the court affirmed Sargent's convictions but remanded for the limited purpose of striking the VPA and interest on his restitution. Please let me know what you think about this case in the comments below. And if you like this video, please hit subscribe for more arguments every week.